Welcome to Doing Business in India. This is Roger Royse. I'm the founder of the Royse Law Firm, a business tax and corporate firm with offices in Northern and Southern California. Today we have a panel assembled to address the topic of doing business in India, demystifying India, and top legal mistakes that companies make going into India. We have with us two representatives from Sannam S4, Adrian Mutton, who has 20 years of doing business in India, lives in New Delhi, and is the advisor to several governments and many international trade promotion bodies. Also from Sannam S4 is Nicole Sahin, who has supported U.S. businesses expanding into over 30 countries worldwide. From Royse Law Firm, we have Harpreet, Walia, and Satya, Narayan, who head up our India practice group. They are both dual licensed lawyers with practical on-the-ground India experience. Their practice is multidisciplinary, and our lawyers are proficient in Hindi, Punjabi, Tamil, and Kannada language. We have an understanding of the legal and cultural aspects of conducting business in India and a substantial network of legal, accounting, banking, and consulting professionals throughout the country. So our speakers are going to give a short presentation. You can follow along the PowerPoint slides online, and you'll notice that there's a text box over on the right-hand side. If you have questions, please go ahead and enter your questions in the text box. We'll gather them and address the questions at the end of the presentation. And with that, I would like to turn things over to Satya and Harpreet.
Thanks, Roger. So India is a dynamic country, and there's been tremendous interest for companies developing their businesses in India, as well as Indian companies looking to develop their practice and business throughout the world. Given that, given this interest, how do companies access the Indian market? And that's some of what we're going to try to address today, dealing with some of the common pitfalls that companies face, some of the legal challenges that they need to overcome, some of the business and other concerns and thoughts they need to think of before they enter into the market. So looking at India, how do you enter into that market? From a legal perspective, the entry into the Indian market is controlled by an act titled Foreign Exchange Management Act, or FEMA. Now this act controls what kind of investments and how a company can enter into the Indian market. If you look at slide 1, we've listed for you a link to Government of India's 2012 Consolidated FDI Policy, along with what is labeled a press note. Now, if you start doing business in India, you'll become very accustomed to dealing with press notes, because these are handed by the Department of Industrial Policy and Promotion, and they essentially amend and augment the policy of the government over various points in a year. So if you connect to this link, this link will show you the various industries and sectoral caps and restrictions. So essentially, India, while it allows generally investment into the country, there are certain restrictions. Certain sectors are limited to certain percentage ownership. And so once you determine that you want to go to India, you need to first determine how you can access it, whether as a 100% subsidiary or as a joint venture partner or having a certain ownership percentage in a company. So some of the more common sectors we've cited here on this slide is single brand retail. So this is an area where the government has allowed 100% foreign direct investment, but there are certain restrictions. As you notice here, there's 30% of the goods must be sourced from an Indian company. So for example, the company that's come in under this is IKEA. They had been waiting for a number of years to enter into the Indian market. Prior to 2011, there was a restriction on the percentage of ownership that a foreign company could have, and now they've lifted that. So you've got IKEA, who's stated that they're going to make an investment of about 150 million euros into the country. But now the challenge is how to meet this requirement of 30% of the goods must be sourced in India. So these are the types of challenges. Now, another area we see is multi-brand retail. That area has now been, is 51% foreign direct investment, but it's subject to state approvals. And there are other restrictions that could apply, and we've listed them here. The key thing to keep in mind is when you want to enter into the country, there are going to be certain restrictions. You need to access that information. You need to find professionals who will help you access that information. So, that's the first criteria. Second criteria is there are automatic routes, potentially, to entering into the country, where you do not need approval from various government agencies. Or if there are certain areas that are stated in the press releases or in the policy that require government approval, then you need to get that government approval. It principally comes from two individual bodies in India. One is the Reserve Bank of India, and the other is the Foreign Investment and Promotions Board. There are certain areas that are still restricted from investment, and we've listed them here: atomic energy, gambling, betting, agricultural, though there are several exceptions to that rule. Just because you can either obtain an automatic investment into the country, or whether you are able to obtain government approval for an investment, one still needs to consider that there are industrial licenses and other restrictions that may apply to a specific sector. So again, it makes it very important for us to review the areas that you're looking to enter into and to see what restrictions are applicable. The last point on investment into the country that I want to make is there are various intermediary jurisdictions that U.S. companies look to in terms of making an investment in India. Specifically, Mauritius is an offshore entity. It's a small island off the coast of India, which has certain tax treaties with India that make it an advantageous avenue to invest into India. So that's another area you want to think of, because the issue that we oftentimes deal with is companies that set up because they're in a rush to set up in India, but subsequently learn that there could be other tax benefits from investing into the country through one of these foreign jurisdictions. So you want to, again, meet with your professional advisors, legal advisors, in terms of how to make that investment. So one of the early ways that companies looked to India were to set up what are labeled liaison offices. Now this is kind of an intro into the country without establishing a corporation there. And the real reason to set up a liaison office is just for promotional activities for a company. It doesn't allow you to earn revenues in the country. It's really there for you to understand what's happening on the ground. There are, even for a liaison office, certain restrictions. First, it has to obtain approval from the Reserve Bank of India and the Registrar of Companies. And even though it is not involved in any activity on the ground, per se, it still is required to provide audited financial statements and tax returns. And as you notice on the second point here, that if it's determined that revenues are being generated, there is a fairly significant surcharge that's attributable to that Indian income. Another option is a branch office. This can be used for commercial activities, but you cannot have direct manufacturing or processing activities in the country. A branch office is subject to tax in India for the income that's generated there. However, it does allow for repatriation of funds. Again, this entity requires approval from the Reserve Bank of India and Registrar of Companies. Both of these entities, if you do get approval, the approval is in place for several years, after which then either you have to renew it or then presumably you've determined the viability of the market, and you move to the next stage, which is, if you move to slide 3, is setting up a corporation in India. Now, we talked very early on about FDI and FDI approval. Well, so long as you're in compliance with the FDI requirements, the foreign direct investment requirements, you can have a wholly owned subsidiary in these sectors. Now, what does that entail? There are certain reporting requirements that are required to register a corporation, even though, again, they may be a direct approval in terms of the foreign investment itself. The registration of the company is administered by the Registrar of Companies in India, and it has its own requirements for a privately held company. They have the title of private limited company in India. There is a requirement that you have at least 2 directors. That can be satisfied with foreign directors, but then if you do have foreign directors, there are additional requirements that they need to comply with. Key things to keep in mind once you have registered a corporation in India. The Indian subsidiary is subject to Indian laws. Even a contract that enters into with local entities will subject itself to Indian laws, and we'll address some of the contracting terms and conditions that you want to keep in mind given this point. Another area that people who do business in India through subsidiaries are intimately familiar with, or should become familiar with, is transfer pricing issues. The government is very aggressive on taxation and collection, and as the India economy grows in fits and starts, at various points in time, the taxing authorities will become more aggressive. And so certainly if you have a subsidiary, you want to engage in a transfer pricing study to make sure you're in compliance with the transfer pricing laws. An Indian subsidiary for a non-resident public company may be treated as a public limited company under certain provisions of the Indian law. You need to keep that in mind. There were certain restrictions in terms of actual on-the-ground presence for board meetings. That has been loosened to some degree, though there's still a requirement for at least once a year for board members to be on the ground in India. Another area to keep in mind for directors who are foreign directors for an Indian company, the director liability, while similar in many ways to the U.S. in terms of certain limitations and protections, there are higher standards of doing business in India for a privately held company. So you do have these government bodies that do look in terms of how a corporation is set up and administered there. So there are statutory penalties for not holding these regular annual meetings. There are statutory penalties if there is a failure to maintain books, records, and accounts. And if a company has to be dissolved and wound up, a director can be held personally liable for the taxes of an entity if there aren't sufficient funds available to be paid by the entity itself. Another thing to keep in mind on an exit when you're setting up a company is a sale of a company, unlike the U.S., even if it's a privately held company, is not automatically a private transaction in the sense that the pricing can be determined between the parties. In India, when you're selling shares in a company, there is a minimum threshold requirement that you have to pay fair value per guidelines that are actually written. So, for example, if you are an entity that has a U.S. corporation that has an India subsidiary and you do a transaction in the U.S. and you internally make some determination as to valuation, well, those valuations may not hold up because they actually have, for the India component at least, it has to be valued at a fair market value. And so that's one of the areas people need to take into account when they're setting up subsidiaries, especially in light of a potential exit down the road. So with that, I will turn over to my colleague Satya, who will start on slide 4, U.S. treatment of Indian employees.
So hello, everybody. India is probably the country with the most complex labor and employment laws in the world. It has more than 55 central labor laws, labor and employment laws, of which the Indian Industrial Disputes Act of 1947 is the most expansive, and then there are over 100 state labor and employment laws. Indian labor laws are very different from U.S. labor laws, and so you should not be assuming for a moment that U.S. treatment of employees should be applied or will apply to treatment of your employees in India. The Industrial Disputes Act applies to all types of industries. The definition of industry is very expansive, and it applies to skilled and unskilled workmen. So even a software engineer who is not in a managerial or supervisory role the Industrial Disputes Act can apply to that individual as well. India does not have an at-will employment as in the U.S. So termination without cause has to usually be subject to a last-come, first-go rule. There must be compensation, severance compensation that needs to be paid to your Indian employees, and it's based on the number of years of service or portion of years of service. And sufficient notice has to be provided. The amount of the notice period depends and varies on the number of workmen or employees in the company. Then the companies employing more than 100 workmen or employees must obtain government approval before they can fire employees. So it's not that easy to wind down your business or your subsidiary. Then when it comes to your Indian employees, post-termination restrictive covenants may be void. There is an exception for non-compete clauses in the context of a sale of the business with goodwill for consideration. And even there, the restriction needs to be reasonable. So non-compete clauses and non-compete clauses post-termination are not valid. Non-solicitation clauses post-terminations are, in all likelihood, not valid. There are some exceptions when it is limited to protecting confidentiality, such as customer lists, supplier lists, as an example. But again, it has to be very narrowly tailored. One of the key things that I advise my clients going into India is protect your intellectual property locally and protect it early on. Whether you're doing business with Indian partners as distributors or franchise partners, or if you are creating a subsidiary, a wholly owned subsidiary in India. Still, I advise the U.S. parents to apply for their intellectual property protection, particularly trademarks and patents, directly in the name of the U.S. parent as far as possible with the local registrars. And the reason for doing this is, going down the road, there might be disputes with the wholly owned subsidiary, control may shift, your distribution partners may decide a different strategy, and at that point, when the relationship starts to sour, you don't want to lose control of your intellectual property. Tailor your U.S. employee invention agreements to overcome presumptions under Indian law. So the employee invention agreement that you use with your U.S. employees, you need to tailor them when you're using it with Indian employees. There are certain presumptions under Indian intellectual property laws, including the copyright law, where an assignment of intellectual property would be limited to the Indian territory if it's not stated expressly to be worldwide. An assignment of intellectual property would lapse after 1 year if the assignee does not exercise those rights within that year. So all of these presumptions of Indian copyright law have to be expressly overridden in the employee invention agreement. As far as your Indian partners are concerned, include no contest terms, which basically means that if your joint venture partner or your distributors contest the U.S. company ownership of its intellectual property, then the license agreement, the business deal comes to an end. And that is really, really important. Confidentiality obligations. Generally, companies do include these terms in contracts with partners, global partners, and the same is the case with Indian partners. The only point I'd like to make there is that India does not have a trade secret law as the U.S. has, and therefore you have to rely on the confidentiality terms in the contract to protect your confidential information and trade secrets. Present assignment of derivative or new intellectual property, it's the same as the U.S. rule. An agreement to assign intellectual property is not the same as an actual assignment of intellectual property. It seems like it's a question of semantics, but it's actually a very important piece here in the U.S., and the same applies in your agreements with your Indian partners and Indian employees. Next slide. Following up on that point actually is using U.S. generic contracts with Indian partners. Not a good idea. Take your U.S. contract, get it reviewed by counsel who do global transactions and are intimately familiar with the Indian scene. Provisions may be ineffective under Indian law, such as a non-compete covenants which exceed the term of the contract. What you don't want happening is you have a post-termination covenant which is invalid under Indian law, and then wholesale sections which are related to the non-compete provision in your contract are excluded or severed because you have a provision which is not enforceable under Indian law. Provisions may not override presumptions under Indian law. Just as we spoke a couple of minutes ago about the IP and copyright laws, those are the presumptions I'm talking about. Those need to be expressly overridden in the contract. And your generic U.S. contract may not do that. Apart from copyright, India recognizes moral rights. Moral rights are not an intellectual property right, and therefore they need to be addressed by an express waiver in the agreement. You also need to have the provisions of your contract with Indian partners comply with Indian regulations. So, for example, if you, in a franchise agreement, the royalties that you set that are payable for the license of your trademark to your franchise partner and the technology transfer related royalties and payments, they need to comply with the Reserve Bank of India's regulations on royalties of, royalties above and beyond which you may need to get RBI approval. There's also a very set method that the Reserve Bank of India prescribes for calculation of royalties. Therefore, the royalty structure that you set forth in a franchise agreement needs to comply with that. So again, provisions must comply with Indian regulations. Then when you do business with Indian partners, something very important, you need a lot of provisions around relationship management, escalation, and interim remedies. What you really don't want is a situation where your partners are not performing and your only remedy in that situation is to take them to court. You really want to avoid Indian court as far as possible, even if you legitimately have concerns that you would normally take to a court in the U.S. So you want to provide for escalation, interim remedies wherever possible that are tied to performance. Particularly, if possible, try to have objective remedies. If that's not possible, then draft in a liquidated damages clause, which needs to be reasonable. However, it's something that you need to think about, talk with counsel, and put in place in your contract. Then for general global transactions and contracts, you want to exclude the UN Convention on International Sales of Goods. Contracts should include certain minimum terms, and this slide lists a few of the terms that you want to include. Next slide, please. So I think joint venture you want to talk to?
Yeah, well, joint venture is another vehicle in terms of how companies enter into the Indian market. The key in joint ventures is, there are certain sectors we mentioned under the foreign direct investment that are limited. So companies may determine that instead of having ownership restricted in a corporation directly, that they set up a joint venture as an entry vehicle. Also, because a joint venture partner may have a better understanding of the markets, production, labor costs, and all of those issues on the ground. There are very important things to keep in mind, though, when you're using this vehicle as an entry point in India. We've identified some of the key provisions here, but I think the takeaway is that various key provisions have to actually be put into your articles of association, or these are essentially your articles of incorporation in California. So these specifically address points such as distribution of revenue, what happens in the event of a deadlock, right of first refusal, and others that are listed here. These are issues that someone would think would be addressed in a joint venture agreement, but if they're not put into an article of association, technically they're not binding on the joint venture itself. So these are kind of key points to keep in mind when you're drafting it. So there has to be a lot of emphasis placed in the actual drafting of the legal documents. I know in most joint venture agreements, it's the business issues that take the forefront. I'm not suggesting that they should not, but keep in mind here you're dealing with the peculiarities of an Indian legal system that will only look to some of these key provisions if they're embedded into an article of association.
And just to add a little bit to that as well, the typical joint venture relationships that have ended up going to court in India or have fallen apart, the reasons for them, though multifarious, some specific ones are, where one of the joint venture partners increases the royalties charged to the joint venture company with respect to new patents that are added. So if that's not something that's been agreed to at the get-go, that changes the whole revenue share balance between the joint venture partners. So you want to address that in your joint venture agreement as well as in the Articles of Association. Some other things that commonly come up when joint venture partners start to disagree and the joint venture has problems is the issue of combined marks in joint ventures. And then one of the joint venture partners contesting, or the joint venture company contesting the intellectual property ownership rights of the joint venture partners. So this slide again goes to the point of when you do business with Indian partners, whether they're distributors, franchise partners, joint venture partners, or service providers for that matter. Failing to state the governing law of the contract, that can be a very fatal mistake. What might happen then essentially is for services and obligations performed in India, an Indian court may determine that Indian law applies. And you really don't want to get mired into that situation because honestly, some of the laws, while the country is certainly moving ahead to do a do-over on a number of legislations and statutory requirements, we still have quite a few archaic laws there. Indian courts respect the party's choice of law for the contract, so that's the good news. So wherever possible, choose U.S. federal and state law. Expressly state that in the contract, and if there's some argument over the partners wanting a different law, then English law is also a good choice. Caveats. Certain U.S. or Indian laws will apply notwithstanding what choice of law you choose for the contract. Things like U.S. export laws, the Foreign Corrupt Practices Act, intellectual property laws, antitrust and competition laws of the U.S. as well as India might apply. Certain kind of contracts will always be subject to Indian law. Those are contracts between Indian parties. So, for example, as Harpreet mentioned earlier, contracts between your your Indian subsidiary and its Indian partners will be governed by Indian law. Contracts with Indian governmental entities, contracts with Indian consumers or individuals will be governed by Indian law. Next slide, please. So, continuing on the governing law and issue, a related issue is you should absolutely specify the mechanism for dispute resolution. U.S. judgments are not automatically enforceable in India, so even if you choose your contract to be governed by U.S. law, you still need to understand, and you provide for U.S. court judgment, then you still need to understand that the U.S. court judgment has to be executed in India, and it can be opened up in Indian courts. The better approach is to choose for arbitration, because India is a member of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. What that essentially means is that an arbitration award, wherever the venue be in the U.S. or India or in UK or any other location, will be respected by an Indian court unless it's for very limited circumstances, such as being against public policy, is generally respected and it's executed by the Indian courts. The only caveat I would say is if you should opt for arbitration as a dispute resolution mechanism, but reserve rights for seeking injunctive relief to protect your intellectual property and confidential information before any courts. Indian high courts are known for granting injunctions within 48 hours for intellectual property, so there's a bit of good news there. Next slide. So I think this is the final top 10 mistakes, and this is a very important one. I recognize that India is a hard place to do business because it is ranked pretty high up there for corruption. However, as a U.S. company, you have to absolutely be aware of the U.S. Foreign Corrupt Practices Act, which has got extraterritorial jurisdiction. As recently as in August of 2012, Oracle settled an FCPA charge by the Securities and Exchange Commission, which related to certain transactions done in India through some side funds. Oracle paid a $2 million penalty to settle that. So it's very real, and the FCPA has been enforcing and has created a special unit in 2010 to further enhance its enforcement objectives. We've listed some anti-corruption best practices. I won't go into detail here on those, but certainly practices you want to put in place, not just with your Indian subsidiary, but also with respect to your joint venture partners and your service providers and your distributors. Finally, just a couple of last slides. I won't go through them, but watch for changes in Indian legislation. There's a lot going on there. An important example is the Companies Act of 1956 is being replaced by, well, shortly, hopefully, to be replaced by what is proposed now, the Companies Bill of 2011. The income tax laws are also changing. We've provided a number of resources and how on doing business with India, the government of India's consolidated FDI policy, Reserve Bank of India's circular on import of goods and services, some information on franchising, and some information that's readily available on IP law through the Comptroller General of Patents, Designs, and Trademarks and their website. All right, I think we'll move then to Sannam's presentation.
Great, thank you very much. Some excellent technical oversight on how to approach the Indian market. I'm Adrian Mutton from Sannam S4, and I'm here with my colleague Nicole Sahin. I'm based in New Delhi, and I've been doing business out in India for 20 years now. And I've seen a lot of change in India, both from a commercial and a cultural perspective in the last 20 years. But a lot of that change has come in the last 4 or 5 years. Some of the points that Satya was just making about keeping an eye on India's laws and regulations is particularly important at the moment. India is putting through a new set of acts in advance of a general election in about 18 months' time. So India is at a period of its economic development that I think is well worth everyone internationally viewing. So our firm is based across India, Delhi, Mumbai, Bangalore, Chennai, and our role is really to take companies who've done their homework domestically, done their research with people like Satya and Harpreet, really understood the market from a technical level, and then want something executed on the ground. Over the last couple of years, we've taken a lot of international businesses into India, and we provide them the practical, hands-on support to execute the work that they're doing. My message to most of our clients is that India, as a domestic company, is no more complicated than America is as an American domestic company finding itself here. And Indian companies find it just as complicated to go into the US as US companies do going into India. When I speak to a lot of my team who are doing the delivery on the ground in India, the things that they're doing on a day-to-day basis are the bread and butter that they've been doing all of their life. So I think getting a combination of good advice from people that know the ins and outs of India, as have just been explained, and then using good practical support on the ground for everything from staff management, relationship management, supplier management, will provide you a suitable safety net to do business. I just want to put India into context. When I come over to the US in particular on regular trips, I feel that there is a little bit of a misconception in certain areas about the Indian market, which I'd like to address today. The growth of the economy has slowed down a lot from a perspective of 8-9% in the last few years back to 5.5%. And there are a couple of macroeconomic reasons for that. The global slowdown has had its impact. Europeans trading slowdown has had an impact, but also the lack of political decision making. And that's why the period at the moment is particularly interesting and exciting for international companies, is because you are seeing aggressive liberalization once again, as Harpreet referred to. Companies like IKEA and Walmart and others are now coming into the market with huge investments, and that will bring behind it a lot of opportunity for suppliers into those international businesses. Both Morgan Stanley and Goldman Sachs have predicted that India will be a faster growing economy than China by 2014, and I'll come on to talk very briefly about the China-Indian comparison, because I get asked that question a lot. But it is certainly on the move. For those of people that call it an emerging market, they haven't studied their history. A fact that often bamboozles people is that for 496 of the last 500 centuries, which is pretty much most of recordable history and beyond, India has been the largest economy in the world. We just happen to have been born in a period where India was considered to be re-emerging. History will show us that the global domination is based in Asia, and I think from what's happening in China at the moment and India following on will clearly show that the West dominance over the last century or two has just been a blip in that trend. One of the statistics that I find most valuable to share with people is that 50% of the entire world's population under the age of 25 lives in India. So for every American child, every Brazilian, every African, every Chinese child, there's another one in India. And we call that the demographic dividend in India. It's an enormous and historically unparalleled rise of a working and consumer-based society, which will mean that India has both a combination of virtually unlimited resources from a labor perspective, and also an enormous opportunity for India to present itself as a domestic consumer society, which other major economies like China maybe have not succeeded in doing. And so for companies that are going into India, the fact that it's seen largely as an outsourcing cheap labor center, that will continue for years to come, providing the skills training is put in place, because there will be an enormous pool of labor. Sometimes I see these days international firms getting caught up in fairly aggressive wage inflation in India, which is a bit of a challenge. But the good news is, beyond the core sources of that labor, there are additional sources that can be tapped into cost effectively. But there are many, many opportunities, which I'll touch on, for international companies to go in and look at the consumer base. And America, above and beyond most other, if not all other countries in the world, has been very, very good at building scale, whether that's in telecoms, in consumer services, financial services, technology. And India needs scale, and it needs people that can deliver quality services, quality products in scale. And I think American businesses of all shapes and sizes and of all sectors have got a fantastic opportunity there. And certainly you'll see that as the youth come through, India's economy will continue to develop. There are a lot of myths and misconceptions about the Indian market, but one of the things I hear regularly these days from companies in the US and Europe is that their domestic markets and other international markets may not be on the move in a way that's going to sustain the type of growth that we've all been used to in the last decade. India certainly does provide a new market. It's coming from a very low base, so I don't sit here and over-exaggerate India's place in the world as a current superpower, but it's certainly going in that direction. And you'll hear something mentioned in any Doing Business in India event that India is a long-term bet. It is a long-term bet, but it's certainly got some medium-term upside as well for those that can successfully establish their business there. The considerations here that companies have not considered India, with a bit of thought, tend to be ones that can be, got over. The large base of English language in India means that transactions are, done in the language that you're used to. The legal framework is based on an English legal framework. And culturally, there are a lot of similarities between where India is developing with the US and an American traditional home base. And I think that it's not unless companies have actually gone into the market and worked with partners that can demystify the Indian domestic scene that they see it as a market that they can do business with. But certainly with the right support and the right advisors around you, it should be no more or less difficult than doing business in Europe, particularly countries like France and Germany, which are technically quite difficult. Just a quick snapshot of where India is on the map. No need to dwell on this, apart from saying that the India-China block that you're seeing in the right-hand side of the screen is where historically the economic power is going. There's a slide that the OECD have just released, which shows that currently the global center of power is around about Vienna, so kind of Central Eastern Europe level, but in 20 years that the global center of all economic trade is going to literally sit on the northeastern corner of the India-Chinese border, and that represents where the majority of trade is done, so that's where it's heading again. India is a large country. It shouldn't be seen as one country from a trading perspective. It's just as complex to do business across India as it can be to do business in Europe. 18 major languages, which is as many as Europe. It takes the same time to fly from one side of India to the other as it does from London to Eastern Europe. And there are individual state differences. The advantage is that if you base a presence there, by and large, you do have access to a single market, underneath one territory, but it has to be thought through about where you actually establish your business in the first place. These are really guidance points to consider. India's got a long-term growth story to it, despite what happens at central government level. There is still an early mover advantage with the country. Many international companies, particularly from the US, have not necessarily taken advantage of the consumer side of the country, which I think is expanding quickly. The retail bill will open that up considerably. And the global shift in economy that I'm talking about means that India has a long-term role to play in the global economy. developing a market entry plan for India should be no different or more difficult to anywhere else in the world, frankly. So there are some good guidance points there. And managing risk is something that I would say is already been touched on. India is perceived as being a risky market, largely because people take it at face value and don't do their homework, and then have horror stories to say. I'm pretty proud of our own track record on putting up the number of companies that we do, that it doesn't have to be a risky market if you do your due diligence and your homework and follow the practices that Harpreet and Satya talked about earlier. And establishing and growing a business there, it's not complicated for Indian businesses. There are many domestic businesses that are succeeding on a day-to-day basis. I only have to step out of my house every morning and see the new cars and the new consumer society that is developing on the back of people earning good profits, good corporate returns there. The trick is to turn an international business environment, product, service into a domestic business and run it like a domestic business, and then ultimately you will succeed. If you go in there trying to run it exactly the same way that you run your business in the US or in Europe, then you're going to find that you automatically get frustrated and get held up, and that's certainly something that we help clients do on a regular basis. I'm going to touch on the China-India story. It's been termed Chindia, and a lot of events people compare the two. I don't like comparing the two, so I'm only going to spend 2 slides on it. But the point of showing this slide is that China's GDP has accelerated at a rapid rate from India's, and China liberalized its economy 22 years ahead of the Indian market, and what you found is therefore its GDP has taken off a lot earlier. So the point where the pink and the yellow lines diverge is purely a representation of that time period. But if you go on to the next slide, you'll see that actually if you'd taken the India versus China growth story at the point that both economies had liberalized, i.e. if they'd have done it at the same time, you see that India's growth story has been slightly quicker than China's and has developed in a quicker rate. What you're starting to see now, which is where a lot of economists are really quite intrigued, is can India take that now accelerated route, which you can see slightly ahead of the yellow curve that the Chinese economy did. That largely depends on India's ability to build and manage the infrastructure that it needs to get to the next level. Massive infrastructure investment is being made at the moment and will be made over the next couple of years, and so the answer is yet unknown. But providing that infrastructure can be provided, and during that period there are tremendous opportunities for many international businesses anyway, providing that infrastructure can be built, India's got a very, very strong future ahead of it. When I compare India to anywhere else in the world, I say to people who've done business in China or they've done business in Europe or maybe South Africa or other BRIC countries, to actually stand on a street corner in Mumbai or Delhi and transport yourself to Shanghai or Beijing and look around you and see what needs doing. And what you'll find is that India still needs a tremendous amount of investment in everything from traffic signals to road quality to the types of cars that are available to consumer choice, and those are the opportunities. So whereas people look at it as a market where IT outsourcing is really the opportunity, of course that is still a fantastic route to very good quality, low cost R&D, but the consumer side of it, the need to develop a street corner in Delhi or Mumbai from what it currently looks like into something that China or South Africa or other parts of the BRICS have turned themselves into, is really the opportunity. And that goes right down to components. So if you go on to the next slide, we've helped companies who produced ball bearings the size of peas and who've expanded across India, and their products go in everything from water filter machines to police sirens to the roll-up handles for car windows. We've got milkshake franchise companies, we've got sports equipment manufacturers, pump condensers, people who provide a piece of plastic that fold cardboard boxes, a whole range of all the way through the supply chain, specialized companies who have an opportunity there. India has largely been dependent on a fairly traditional way of manufacturing. What you're starting to see now is the need for good, strong engineering, intellectual property, good quality products, good quality services, and for those companies that do have a product that stands up to itself and can produce it or supply it at the right price, India is a tremendous market to explore. A number of these reforms were touched on earlier by Satya and Harpreet, but just reiterating them there. The domestic market is really the area that I get very excited about for companies coming into the marketplace from a new sales perspective, because there is a need to consume products that frankly don't exist at the moment, but India craves. The next slide we're going to move on to, just highlights some of the points that I've been talking about. I won't reiterate these, apart from saying that a lot of these seem to be areas that people get very nervous about. But if you position yourself in my shoes, where I sit in my office and I see all of this going from a day-to-day basis, it doesn't have to be complicated. We built my business up from 0 to 75 staff in the last few years, and we've been through a lot of these challenges firsthand as well as with our clients. And it really is people just you're trying to understand how things are done as a domestic firm rather than try to put the round peg in the square hole. Harpreet and Satya talked about some of the approaches that are taken. Essentially, you have the direct routes, and one has to consider the best approach and actually take some time to consider the best approach. A lot of companies just jump in, set up a subsidiary of some type because they need to get going in the marketplace. That can actually long-term create you some problems and slow you down and mean that you have to unwind your entity, which is a pretty tedious affair, frankly, in India. So get it right the first time. Indirect through distribution channels or resellers. We do a lot of market research and market scoping for our clients, where we are identifying the right partners in the right sectors and doing that due diligence and making sure that your interests are going to be looked after is really key. And there is another way. We as a business provide a lot of our clients with an incubator service that we call Launchpad, which is essentially where we house companies, entities in a surrogate format. We house their staff until they've got to the point that they know exactly what type of structure they want to put on. So we take the legal responsibility, we take the compliance responsibilities, we take the HR and employment responsibilities off that company's shoulders until they've actually got themselves set up, to avoid the situation that Harpreet touched on, which is where companies go in, they employ someone straight away before they've actually thought of the consequences. And it's a lot easier to put someone on a legal platform while you're thinking about the right approach to go on to. These are just some key points about how it's set up in the market. Touched on most of them, and Harpreet and Satya has talked on the registered company versus the JV. So I won't talk on these, and these slides are going to be made available to you, so you can look through those, and I'm sure Satya and Harpreet will be able to address any specific questions. This is the model that I was talking about, the Launchpad stroke SEO stroke PEO model that we call it, and it's certainly something to be considered while you are really trying to establish the right type of legal base for your company in India. I throw up some costs here, really not going to go into them in details, they'll be there for you to refer to, but we like to be very straightforward and transparent to our clients about how much it should cost to enter into the market. I think that saves them a lot of confusion. But India doesn't have to be a costly market to enter into at the outset, but also it's worth making sure you do understand what the longer-term costs are, because certain areas of India, certainly real estate, hiring offices, and making sure that your business is compliant can stack up if you don't go about it in the right way. I'm going to hand over briefly to Nicole, my colleague, who's going to talk to you about outsourcing R&D and software team.
Sure. Hi, my name is Nicole Sannam. As we discussed, basically here in the Silicon Valley and a lot of our clients in North America, generally they tend to be software teams that are hiring engineers in India. So I wanted to touch base briefly on some of the ramifications of that and a lot of the questions that I normally get from clients here in the U.S. So depending on the type of hire for an engineer in India, you might spend between $12,000 U.S. per year and $60,000 per year for each engineer. So that's based on a couple job descriptions that I ran through my recruiter. The $60K per year would be quite a senior level hire, and the $12K per year would be a straightforward job. Our recruiting team's advice is that the best high-quality engineers can be recruited from really high-quality schools and from local companies. So when we have a job description, our recruiter runs it by and finds local companies that she can compare it to and recruits from those companies, same as we would do in the U.S. Key cities for engineering recruiting include Bangalore, Pune, and others. It just really depends on your exact hiring requirement. There's no need to undertake separate registrations in each city. To clarify, so unlike China, you can have one subsidiary to do business in the entire country. There might be separate employer-related registrations, but you don't have to set up separate companies in each city. So for example, a company hiring one engineer in Delhi can also hire engineers in Bangalore without setting up a separate legal entity. Primary challenges include recruiting staff to what may be seen as a startup local office. So the prestige and the brand name is important to Indian personnel and their families. Also, a lot of companies based in the Silicon Valley and in Boston, for example, they might request that the employees work from home, which is fairly normal in the U.S., but it's quite unusual in India. And there's not usually the same comfortable home setup or the idea of the work from home culture. Retaining employees can also be a bit difficult because there's such a demand for high-quality engineers that they tend to leave quickly. So I've had a lot of CFOs in the Silicon Valley complaining that their employees in India will quit after being with the company for 1 year for $1,000 raise. The title of your employees will be extremely important to them. So we find our own employees in India constantly negotiating for a better title. It has to do with the prestige that a person is seen with in the society, and they often will negotiate for this harder than they will for the actual financial compensation. And my recruiter indicated the better the title, the better the life. So it has such an impact on one's social standing that it's really important to give your employee that respect that they deserve. In addition to the cost highlighted on the prior page that Adrian touched base on, we budget about 17% per role for recruiting and about $5,000 to $10,000 in employer legal setup work for a team. So basically employment contracts, handbooks, policy to sign, etc. Okay, I just wanted to touch base and kind of wrap up a bit by highlighting the top 7 mistakes that I've seen U.S. execs make when they go into India. The first is to shoot first, aim later. So more often than not, I have a U.S.-based company that comes to me with a signed offer letter, and they haven't considered what type of legal entity they need to set up, how they're going to run payroll, where the location of the employee is, what their long-term plan is for India. Given that it's such a huge country and it's so difficult to unwind later, much less set up from an administrative perspective, we just definitely recommend spending about 6 months, coming up with a plan before you issue that first offer letter, if not a year. Number 2, expect it to be free. The idea of India as being a cheap place to outsource, it's not really a cheap country. I mean, in fact, we would say that, it's less expensive in terms of salary, but there's 2 issues here, and this touches base on number 3. First, if you treat your India team like cheap labor, they're not going to appreciate it, and they're not going to give everything that they can. These are usually, when you're recruiting, you have to treat just like you would in the U.S. Your employees and give them the dignity and respect that their very high-level degrees and what they can bring to the company dictate. And it's not free. There's a lot of administrative overhead. There's a lot of issues with flying people back and forth from the U.S. And so, in general, the first year is about as expensive as it would be in the U.S., and then the returns on the investment, if you're trying to save money, they do start to show up in the 2nd and 3rd year. Number 4 is ignore local relationship building practices and culture. So, for example, when building a sales team in India, things take time. You can't fly into the country and expect to have 4 meetings in a day and fly back out and expect to have a signed contract. It's just not the way it works. There's definitely a long and ancient culture of building relationships with people, and your credibility is based on those relationships. So it's really important to spend some time in the country. Number 5, assume you can hire and fire at will. At will employment is kind of a U.S. thing. So it's not really the same, and there's a lot of labor laws to be aware of, which Harpreet and Satya touched base on earlier. Number 6, hire one person to cover the entire region, especially a high priority for sales. Depending on what you're selling, it's really important to place the person in the right region and make sure that they have the right contacts. A lot of U.S. companies would hire someone that they've met a couple times or that they know quite well, but they might not be the right fit for the role and for the country. And number 7, again, is that the mistake is to underestimate the length of time for planning. So with that, I'll turn it back over to Roger for questions.
Okay, I'd like to thank the panel. I think we'll go ahead and conclude at this point since we're at the top of the hour. I'd like to thank the panel for participating. For those of you who would like the slides, they will be available on Royse University website, and a recording of this presentation will be available on the Royse Law YouTube website. So again, thank you, panel, and we look forward to hearing from you.